Okay, so the next topic here, we're going to be talking about some advanced water right topics. My name's Michael Drake. I'm the regional engineer over the Weber office, and there's, let's see, I guess no contact information, but so we're getting into some advanced water right topics here, and the topics we're going to cover here are forfeiture, non-use, and the non-use application. And then we're going to cover rebuttable presumption of quantity impairment due to non-use. And this will address the question we had earlier from Cedar about quantity impairment. So each of these topics revolve around the concept of non-use. Okay, so before we get too much further in there, this is a topic that can go off the rails pretty quickly. And so I do want to encourage questions that help us to understand, so please don't take this to say don't ask any questions, but very project-specific questions is probably not the best place to bring it up. We can talk afterwards, we can talk if we've got time at the end, but by all means, if you have questions that help us understand the concept, go ahead and bring those up. Okay, so let's the Utah Code 7314 is where you go to find the statutes regarding forfeiture and non-use. Forfeiture is a very fundamental concept in the doctrine of prior appropriation and in water rights. So in Western states, water is a public resource. It's managed by a system of water rights, and so when we have these water rights, we're supposed to be using them. Okay? And the subsection 2A that I have up here, it describes the relationship of non-use, what happens when someone isn't using their water right, okay? And so let's read that. When an appropriator abandons or ceases to beneficially use all or a portion of a water right for a period of 7 years, the water right or the unused portion of that water right is subject to forfeiture. Okay, so I've underlined two parts of this part from statute. All right, and they each teach us a different concept about this. First, we get the definition of non-use, or what non-use that means something here, right? And so it only becomes a problem when it's done for a period of 7 years. Okay, and at that point, at 7 years, this water right is subject to forfeiture. Now that phrase right there is very important to note and understand, specifically as it relates to the state engineer. Okay, it's subject to forfeiture. There isn't an automatic thing where you don't use it for 7 years and the water right, poof, it just disappears. That doesn't happen. Okay, it's subject to forfeiture, and there are processes that have to be gone through for that to actually happen. Okay. Okay, some facts on forfeiture. Okay, forfeiture is a judicial proceeding. Okay, and I have under that little subheading, administrative versus judicial action. Okay, administrative actions are actions taken by the state engineer, and forfeiture is not one of them. The state engineer does not have the authority to declare a water right forfeited. That only can be done by a judge through the judicial process. Okay. Now it's true that forfeiture occurs in the course of an adjudication, but again, this is with involvement of the courts. All right. So even with this forfeiture, this judicial forfeiture that we're talking about, there are some conditions, and the condition is the forfeiture proceeding has to be filed within 15 years of the latest period of non-use of at least 7 years. And then this plus, there's this, and this is maybe a difficult one to understand, but plus any approved non-use periods. Okay, so if a water right has not been used, it's not forever tainted. If it's returned to use, then that after 15 years of use, that non-use period is no longer subject to forfeiture. Okay, now the little caveat is plus any approved non-use periods. A non-use period through a non-use application lets us continue to look further back in time before that non-use application. Now we'll go into a little bit more detail, and that'll make more sense a little bit later on when we talk about non-use applications. Okay, another big question that comes up is if forfeited, what happens if a water right is forfeited? Well, it reverts to the public. Okay, and this is a frequently misunderstood concept right here. It's not the winner of the court case doesn't get the water right. It reverts to the public, and then what happens with it then is kind of up in the air according to what that specific area is like. If the area is close to new appropriations, then it is just it hasn't been used, and so that water has been used by others in priority. Okay, if the area is open, then that water, it wasn't used anyway, but it is now part of the pool of water that can be appropriated by new users. Okay, but the big misunderstanding on this is that the winner of the lawsuit doesn't get it. Okay, and another question that came up last year at this event was how can you find a water right that's been forfeited? What in the database denotes this? And so in the database, you'll see that the status is listed as terminated or disallowed, with disallowed pertaining to water rights that are forfeited through the course of an adjudication. Okay. Any questions on that? Good point. Maybe take a little question if anyone has one. Yes, sir. Microphone. Right up here.
What if this water that's been forfeited is on private property? And you said it goes back to the public.
Yeah.
How are they going to use it?
Well, we talked about that. So it depends on the area, right? And so remember, water rights are a public water is a public resource, and it's through the water rights that you are able to make use of that public resource. If you're not making use of it, then it goes on to the next person in one way or another. If it's a closed basin, then others in priority now get to use that. If it's an open basin, it's just part of the pool of water that can be appropriated by by applicants, by people that want to place water to use. Does that make sense?
I guess.
Okay. Let's see. All right, so who files a lawsuit in this case? Typically, it's an aggrieved party, someone that can be harmed, usually by that water right coming back into use. And then the other case is the state engineer certainly can bring a lawsuit of forfeiture. Most typically, this is done in the course of a general adjudication. Now, we're going to have an entire presentation on adjudication, so I don't want to get too deep into this, but in an adjudication, water users submit claims, they're evaluated, and if they're found not to be valid, they're listed as disallowed, which is effectively the same result as a forfeiture. And another little aspect, another detail is that once in an adjudication a decree has been issued, that bars, it kind of sets up a wall where you can't go behind that decree and assert non-use on a water right prior to that. Okay. Okay, so statute also recognizes that there are several instances where non-use can be excused, and these are very important. You're going to see these a few times throughout this presentation, because they relate to non-use and to the rebuttable presumption of quantity impairment. As we go through these, there's two slides. Some of them are pretty clear, some of them maybe not so much. What they exactly mean, I may not necessarily know. This is why forfeiture is a judicial proceeding. Some of this needs to be determined by a judge, and so get a good attorney. All right. So number one, approved non-use application. We'll talk about this in a minute. An approved non-use application is an exception to non-use. A lease, if you're leasing your water to be used somewhere else. Now, you might need a change application to do so, but a lease protects your water right from non-use. A government fallowing program, insufficient water. And this one's, let's dive a little bit deeper on this one. Last year we had a pretty bad drought, right? This year looks to be pretty good, so we've all forgotten about that. But if you would have used the water if it had been available, but wasn't because of of drought, then maybe your water right is protected from non-use. And related to that is priority cuts. This brings into mind a distribution system where we have a river commissioner. If you're cut by a priority date and for some reason you can't divert for a given period of time, then maybe you're protected from non-use. More exceptions, water storage, either on the surface or in groundwater recharge projects. If you use substantially all of the water that your water right says you have the right to use, you may be protected from non-use. All right, another big one. We usually have a lot of public water suppliers or people that work for public water suppliers. If you're a public water supplier and you acquired your water right prior to May 5th, 2008, your water right is protected from non-use. Okay? Now, the question that should be jumping around in your brain is, okay, what if I acquired a water right after May 5th, 2008? Statute says that you need to file a change application and get that approved to have this same non-use protection. Okay? A supplemental water right is protected from non-use. And finally, if you're diligently pursuing a change application, you're protected from non-use. Okay, I'll stop right here. And any questions on any of these? Yes. Yes, sir.
You said to get a good attorney. Can you recommend one?
There are many good ones.
Probably a couple in this room.
Ooh. Does anyone want to do some marketing? No one wants to do any marketing. No, I search for Utah water right attorney. That's generally what I tell people to do, and you'll find a lot that we work with. Just search that on Google, and you'll find some.
Thank you.
Yeah. Any other questions? Okay. Okay, non-use application. So I've mentioned this already, and it was that first exception on that list that protects you from non-use. So statute also recognizes, in addition to those exceptions, that there are times not covered by that list when a water user cannot use a water right. Okay, and that's why a non-use application exists. So what does it do? A non-use application protects from non-use during the period from filing to expiration, and that's key to note right there. Okay, it doesn't go, merely getting an application approved doesn't forgive any past non-use of a water right. It only protects non-use from the period you file until the until the date that it expires. Okay, so it doesn't protect a water right that is already subject. It also does not constitute beneficial use, and what I take from that is that if you have a proof due date, that remains. You still need to submit proof. You might need to submit an extension, okay? But a non-use application does not constitute beneficial use.
Mike?
Yes.
There was some question about what that means. In the statute, it says if you, water subject to forfeiture, if you put it back to use for 15 years, it's protected from forfeiture. People were of the impression that they file non-use applications and file them as a protection from forfeiture for 15 years, then that water right is good again. And so the legislature was very clear that those non-use applications do not count as beneficial use or putting the water back to use to qualify for that 15 years. It's not the same thing. So.
Okay, excellent. Thank you, Kent. And that's important. That 15-year mark plus the non-use application periods. So you could have 5 of those non-use application periods up and still have some non-use back there, and that can still be an issue for you. Okay. A non-use application can be filed on all or a portion of a right by an appropriator or an appropriator successor in interest. It can also be filed by a shareholder with shares in an irrigation company. But in this case, you need to give written notice to the irrigation company that you have done so. Yes. Right over here.
As a water supplier, we collect the water rights at the at the stage of approving a subdivision, for instance. But that subdivision may be completed in 5, 10, 15 years. So I'm beyond that 15 years for proving the beneficial use. Do I need to submit non-use applications over a period of time, or should I include that as part of my 40-year water demand plan? Which one of the two is the best?
Well, I don't know if it's a selection of one or the other. You need to make sure your water right is used. And so in this case, and this is a very common thing that these public water suppliers are running into, is the time period that elapses between that. So what I would say is make sure the water right is being used. If it's not, or if you can't, then as a public water supplier, get a change application approved. Once that change application is approved as a public water supplier, you are exempted you're protected from non-use. Okay, but again, that's conditioned on having a change application approved if it was acquired after May 5th, 2008. So that's what you should do, is show that. The 40-year plan that he referenced to is going to be talked about later by Ross in let's see, the very next presentation. Okay, so he'll go into that. Any other questions? Okay. All right, so let's see, I went backwards. All right, so the state engineer may approve or reject non-use applications. For the state engineer to approve, the applicant must demonstrate a reasonable cause for non-use, and this is an excerpt from the statute. Statute has given some examples of reasonable cause, and we'll go into those on the next slide.
We have a question from
Yes.
Cedar City. All right, so if your neighbor is not using his or her water right for longer than 7 years, and then you file a lawsuit against that neighbor for non-use, if she begins to use the water right immediately, does that null the grounds of a lawsuit?
No. No, it doesn't. Statute indicates that it would have to be for 15 years. That's where that time period comes back into place. There would have to be a period of 15 years of use for that to get to the point where you statutorily can't reach back and assert that non-use. Whoops. I hope that answers the question. Okay. All right, so reasonable causes for non-use include all of these listed. Financial hardship, physical causes that render the use beyond reasonable control, water conservation or efficiency practices, operation of legal proceedings, water held by a water supply entity to meet the reasonable future requirements of the public, where non-use will assist in implementation of a water management plan, loss of capacity due to deterioration of the water supply equipment. In this case, it has to be accompanied by a plan to restore use. Okay? Now, an important aspect of this, this is kind of like the other one. What do all these mean? It's a good question. When you submit a non-use application, it's best if you tell us how you think your situation applies to these reasonable causes. Or, you note I say that the reasonable causes for non-use include, it's not limited to just this. Statute is kind of open-ended in that it leaves room for other reasonable causes. Who determines if it's reasonable? Well, that man right over there. And so you need, if you're submitting, when you're submitting a non-use application, I encourage you to submit submit evidence. Tell us what's going on. We frequently get non-use applications that are basically a 1 or 2 sentence description, and oftentimes if it's a second one, it matches exactly what they said the first time. We'd like to know what's going on. Why is this additional protection warranted? Okay. All right, we're about ready to move on from non-use and non-use applications. Are there any last questions on this? We're jumping into quantity impairment next. Anything else? Nothing else from Cedar? Nope. Okay. 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 So this is in response. This will answer the question we had earlier on quantity impairment. Okay. Now, the very first thing to note here, and Teresa talked about this briefly, but this is an approval criteria for change applications, and this entire concept is limited in use only to change applications. Okay, and you'll see the statutory basis is found in 73.3.3 and 73.3.8. All right, so at its very fundamental nature, let's just get the definition of what quantity impairment is. Okay, and that's in 73.3.3, subsection 1C. Quantity impairment is a reduction in the amount of water available to an existing right if a change application were approved, which results in diminishing the quantity of water, a change in timing of water, or enlarges the quantity of water depleted by the water right. Okay? This is the fundamental definition of quantity impairment. And now note, we haven't brought non-use into this yet. We haven't said anything about non-use, okay? We're gonna develop this a little further on the next slide, but in short, what does this say? This basically says that in a change application, you can't do something that's gonna detrimentally harm someone else that was already there, another water right, okay? Now let's develop it. Next slide. All right, now this is where we get into a little divergence here. All right, so in a change application proceeding, and we've read this before earlier today, the applicant bears the burden of producing evidence that the change can be made, including, and then we have this breakout into two different subsets. We have A and we have B, okay? So let's cover A first. So it says, including evidence that the change will not cause a specific right to experience quantity impairment. What's quantity impairment? It's a change in quantity, timing, or enlarging the depletion of the water right in a way that harms another water right. Okay, the A type of quantity impairment is the type of impairment that a junior water right causes to a senior water right. Okay, so water right A is here. Another water right by change application wants to come in and move in and take some water. If that second water right is going to diminish the quantity, change the timing, or enlarge the depletion, that is what I'll call basic quantity impairment. Okay? So as defined, basic quantity impairment protects a senior water right from the effect a junior water right may have because of a change application. Okay, so that's type A. Now let's move on to type B, and we'll give you a chance to process this and ask questions if you need to. So type B, so again, the applicant bears the burden of producing evidence that the change can be made, including rebutting the presumption of quantity impairment. What the heck does that mean, right? Okay, this is where the idea of non-use comes into play. And let's break down that phrase a little bit. So first off, under a certain condition, and spoiler, it's non-use, it is presumed that a change application will cause quantity impairment, which is, quantity impairment is the diminished quantity, change in timing, or an enlarged depletion, okay? So now that presumption is rebuttable, all right? And we'll talk about how that can be rebutted in a minute. But before we go any deeper, it's important to understand that we have a bit of a divergence here, okay? We have quantity impairment, which is a fundamental, which we had that fundamental definition, okay? And now the applicant has a burden to produce evidence to explain away either one of them. Type A is what we'll call basic quantity impairment. This is a standard approval criteria of all change applications. Okay. Type B, and I think if I did my PowerPoint magic, it blinks. Rebuttable presumption of quantity impairment is the type of impairment that is associated with non-use and only comes into play under certain conditions. Okay, now let's stop real quick and just see if we've got any questions here. We're going to get into how to rebut it in a minute, but are there any questions on quantity impairment and these two diverging principles? Okay, wow, I must be doing an awesome job. And that's probably the case. It took us about 2 years to get to the point where we had the forms out ready to go, so. Okay, let's get away from my blinking bee. All right, so we'll try and we'll try and develop this B type a little bit more now. I hope you do understand the A type now. Now we're gonna build on this B type. So under what conditions? I gave a little spoiler about what the condition was, but under what conditions is there a rebuttable presumption of quantity impairment? Well, this is how the state engineer can consider non-use during the change application process. So let's make it even more boring. Let's read statute. We're going to go to 73.38 subsection 6C, and it reads, there is a rebuttable presumption of quantity impairment to the extent that for a period of at least 7 consecutive years, a portion of the right identified in a change application has not been diverted from the approved point of diversion and beneficially used at the approved place of use. And believe it or not, we actually made that more simple in the recent legislative session. It was worse before. So, all right. So that is kind of a hard thing to understand. Okay. So let's get into this a bit. So basically, what this is saying is, if you haven't been using a water right, like you should be, the presumption of quantity impairment may apply. Okay, so if you're not using it at your approved point of diversion and an approved place of use, this rebuttable presumption of quantity impairment may apply. Okay, all right, so let's get into the details a little bit, and this is what differentiates it from the A type. Okay, this rebuttable presumption of quantity impairment is how a junior water right can experience quantity impairment from a senior water right that has not been used for at least 7 years. Okay, and that's a little bit of a reversal from what we talked about with the A type, where it's a senior water right that's affected by a junior water right. Okay, by non-use, this is a way that a senior water right can impair a junior water right holder. Okay, so why can't a senior water right be impaired by a junior water right that is not being used? I'm going to open it up to questions. Anyone have an answer for that? Why can't a senior water right be impaired by a junior water right that is not being used? Priority, right? It has priority over it, and so it can't be impaired. It's not being harmed by it. Very good. Okay, however, a junior water right, so the reason this makes sense is a junior water right may have come to rely on the senior water right's non-use. And so thus, with that water right coming back into place, that impairs it. And what's quantity impairment? It is a change in quantity, change in timing, or an increase in the depletion. Okay, so that's how quantity impairment applies to that junior water right. Okay, so this is what defines a rebuttable presumption of quantity impairment. Are there any questions at this point? Yes, ma'am.
So in your prior slide, are you talking about a water right within a change application, or that's not inside a change application?
It must be in a change application. Quantity impairment only applies in the change application process.
Okay, so can you clarify when you're talking about if you haven't been using the water like you should? That's confusing to me, because back almost maybe a couple decades ago, when you would file a change application, when it was approved, you would see on your memorandum decision where it would literally say, continue using water as it was heretofore used, otherwise you risk forfeiture. Later, in subsequent years, I've got newer change apps that say the opposite. They say discontinue using the prior water use, say it was irrigation, you took it into domestic, once the change application was approved. So completely opposite verbiage. I've gotten different change applications.
And I've actually never run into that first one. And I don't know, Ken, you got a better memory, well, longer memory than I do.
Do you know what I'm saying?
Recently, the legislature has come back and established some new reasons for protection against non-use of water, and one of them is having an approved change application. And so if there's an approved change application on the right, it is not subject to forfeiture. And so when that change was made in the state, prior to that, it was not clear, and the position the state engineer took on that was that if you need to continue to use your water beneficially.
On the
So if you-
heretofore use.
Yes, and so that instruction would have been, someplace you need to use it, so use it heretofore. As it transitioned to the hereafter use, then you would diminish the heretofore use and use it at the hereafter place. But beneficially using the water had to be done, because some people were filing changes and they stopped using the water. Well, there's no protection for a change application back in the earlier years. But since that change has gone into effect, now with the legislature, it's a statutory change. That is protection against non-use. And so the instructions now would be, you need to use it at the hereafter place of use.
So is the effect of that new statute go back in time? Is it retroactive? In other
No.
words, because you had old change applications that would instruct an applicant this way, and now it's instructing an applicant a different way. Stop using on the heretofore, because it's almost like before then they're treating it as double dipping. Oh, you're still irrigating this 10 acres over here, but that 10 acres of irrigation got changed into domestic over here. Now there's homes built over here.
Okay, and the law states what the law states. The position of the Division of Water Rights is that if there is an approved change application, even if it was approved a long time ago, that is protection. And so, yes.
So it is
go back.
retroactive.
And so, yes, and so
Okay.
that's the way we are treating it. Now, that could be subject to somebody challenging that in court, saying, no, it can't be retroactive. But that's the way we are treating it. That was the intent, the legislative intent, and the direction given to us by the legislature to take that position. And so that's the position we are taking.
Okay, thanks.
Okay. Any other questions? All right, let me make sure. I was going to go back and help with that discussion. But all right. Okay, so let's talk about the administrative procedures. How is rebuttable presumption of quantity impairment implemented in the state engineer's office? All right, so statute tells us that this rebuttable presumption of quantity impairment can be raised by the state engineer within 90 days of filing. And so division staff reviews each and every application, and we look at whether there is a potential non-use issue. It can also be raised by a protestant in a timely protest. And a little sidebar here. If you're a protestant and you're raising non-use, please be clear. As you can see, we have one definition, quantity impairment, that can kind of mean two different things. If you're asserting non-use, please say so. It's kind of difficult to read minds through a piece of paper. If you're alleging basic quantity impairment, say specifically what you're alleging. And we need to know whether we need to go into this rebuttable presumption of quantity impairment issue. So if you're a protestant, please be clear on your protest. Quantity impairment's become kind of a catchphrase. It's used in pretty much every protest now. It's like quantity impairment. So please be clear. Now you must identify a water right that will experience quantity impairment. And note, this is goes back to a slide or two ago, that water right needs to be a junior water right for a rebuttable presumption of quantity impairment to apply. Okay. So what might happen after that? Well, if it's raised by the state engineer, a letter is sent out. If it's raised by the protestant, a letter is also sent out saying that the state engineer interprets the protest to have implemented this rebuttable presumption of quantity impairment. Hearings might be held, and again, this is remember how that statute is worded. The applicant bears the burden of rebutting the presumption of quantity impairment, and so the applicant must respond. Non-response on an issue like this can be very damaging. We need to know. Statute's pretty clear in that an applicant bears the burden of responding to this, and so please don't ignore the letters. Okay, so how do you rebut? Well, statute tells us it lists 4 different categories on how to rebut the presumption of quantity impairment. And so it says it does not apply if it's excused by those exceptions to non-use, and if you wait a minute, I'll pop them back up. An approved non-use application. So if you have an approved non-use application, that rebuts the presumption of quantity impairment. In-stream flow. I won't go into this one too much. That really only applies to a couple entities in the state. And then also the passage of time. Here this resurrects its head again. The non-use period of 7 consecutive years must have occurred within the last 15 years, adding any non-use period, any approved non-use application period. Okay, so again, here are those. Oh, I forgot how this worked. There we go. And those are the exceptions to non-use. We've looked at those, okay? Now I want to talk about a couple of them just a little bit more. We've kind of talked about these a little bit already, but let's hit it again. A couple of the exceptions that we get a lot of rebuttals we get address these two items. Number one is leases. This is a very common way to respond. Written documentation is preferred. Again, the applicant bears the burden, and so you need to demonstrate to us. There are some that have said, "Hey, I have a verbal lease with Farmer Joe," and that might be the case, but we need to know. We need evidence, and then most importantly, can that use be terminated? That's a condition with any change application. If it's proposing to move from one place to another, that use needs to be terminated. Can that lease be terminated? That's going to be a key question we're asking. And again, public water suppliers, and again, that May 5th, 2008 date kicks in. If it was acquired prior to that date, then it's protected from non-use. If it hasn't, then it might be subject to non-use, even if it's owned by a public water supplier. Whoops. I'm trying to turn pages, and I keep pushing the button. So much for hand-eye coordination. Okay, so I got a couple scenarios that we can go through, and I think we're coming up on, well, we're okay, but a couple scenarios here, examples. Let's test your understanding. Okay, scenario number 1. Farmer Bob files a change application on a water right with an 1870 priority date. The historical place of use is now a Walmart parking lot. A protest is filed by someone with an 1861 priority date alleging quantity impairment due to non-use. All right, so question, has a rebuttable presumption of quantity impairment been raised? It has not been raised. Oh, I don't think you're getting it. It has not been raised. Look at the priority dates. Who's alleging quantity impairment due to non-use? A senior water right holder. Can he be impaired by non-use? He can't. Okay, so what could we change to make quantity impairment by non-use be an issue? Could swap the priority dates, right? Well, you don't get to do that in water rights, but the state engineer could also raise, or perhaps a protestant that does have a junior water right could come into the picture, right? Okay. Another issue, and this is maybe more common for our public water suppliers. In 2005, a developer deeds 100 acre-feet to Ogden City for development. The water right has clearly not been used for 20 years. The city updates title with the division in 2012 and files a change application. Is there a rebuttable presumption of quantity impairment? What do you think? No, why not? It's before 2008, right? They acquired it, even though they didn't update title until 2012, right? It was when they actually acquired the water right, and that's the key date. Okay, what if the deed was signed in 2012 concurrently with the title update in our office? Does rebuttable presumption of quantity impairment apply? It would in that case, because we're after 2008. So if the water right hasn't been used for 7 years, then we might have a problem there. Okay, so this is the final slide here. So what do you do if you get one of these letters? Well, first off, like I already said, don't ignore. The applicant bears the burden of rebutting the presumption of quantity impairment. Next, look to see if non-use is excused in some way, whether it's those exceptions or that list of 4 categories like a non-use application. And my advice is preemptive strike. Make your case in the application. You might be able to avoid it some protests that will raise it. Tell us why, if there is a non-use, why it's excused. How is a potential rebuttable presumption of quantity impairment rebutted, basically? And I also think a heretofore map would be an awesome thing to do. Tell us exactly what's going to be retired in the change application. Those are things that will help you overcome that and maybe even avoid the issue in the first place. Okay, so that is the end, and I'll take any additional questions we have.
I've been seen in protests where the protestant will just make a bare assertion of the rebuttable presumption of quantity impairment, and it looks like that's been enough to then trigger the letter from the state engineer's office to the applicant that they need to rebut. And when I read the statute, I feel that the protestant should have some additional burden to, other than just saying, I don't think you use this. I feel like they've done no research, they have no basis to believe that. I think that maybe they should, under the statute, have to show a little something that's suggestive that there's been non-use. But I was curious what your view is of that.
Yeah. Well, I guess I'll disagree with you in saying I think the statute's clear that as it's worded, you just bring it up and it's there. It's an issue. Now, we have discussed in the past how the level of detail in the protest probably equates to the level of detail necessary from the applicant to rebut. A very weak protest alleging non-use probably doesn't need, a massive response, because it is, like I said, quantity impairment's thrown around a lot in protests, and sometimes it's hard to determine whether it's non-use or not non-use. But even if they do say non-use, it's hard to determine really how much work did they really do here. So I think statute's clear in that it is implemented. And so I think us as a division are bound to follow the statutory process. But I know that our approach is to weigh the standard of proof given to the standard of proof required of the applicant, if that makes sense. Any other questions? Okay. Very good.